Hi everyone, welcome to the Virtual Amicus, and I'm Jay Ludha. So today we have a special segment, and a segment in which a speaker would be dealing with two topics. Yeah, that's right. So the first topic would be regulating the institutional arbitration in India through Arbitral Council, and the other topic would be structuring internships during a law school. So to elaborate further and dealing with these two topics in detail, we are joined by Mr. Prakhar Agrawal, a very young and a dynamic advocate practicing before Honorable Rajasthan High Court. And just to give you all a brief introduction about our amicus for today's session, Mr. Prakhar Agrawal is an advocate at Agrawal and Company, regularly appearing before the Honorable Court of Rajasthan, Consumer Forums and Tribunal. He's an advocate at Virendra Agarwal and Company, and he specializes in matters pertaining to constitutional, commercial, insurance, consumer, and arbitration laws. He is an incoming LLM candidate at the Hong Kong University for the Arbitration and Dispute Resolution course. He is also an associate member of the Chartered Institute of Arbitrators UK, an alumnus of Government Law College Mumbai. He has keen interest in alternative dispute resolution processes and was fortunate to work with sitting judges of the Honorable Supreme Court of India and Honorable Rajasthan High Court. So thank you so much there, Mr. Prakhar Agarwal. You took out time on a busy working day during the lunch hours. So sorry for spoiling your lunch time.
It is my pleasure to be on this platform here. And I really want to tell you, this is a wonderful platform that you have started, because young practitioners like me really get a glimpse about the insights from different practitioners who come here and give their viewpoints on the niche areas of law. So more power to you, and thank you for giving us this platform.
Thank you so much there, Mr. Agarwal. These words mean a lot. So in our first segment, Mr. Agarwal will be throwing light on the Arbitral Council of India. And just to give you all the viewers a brief introduction about our topic, in the first segment, which is Arbitration Council of India, there was an amendment that took place in the Arbitration Conciliation Act, which is the amendment of 2019, which was introduced in Rajya Sabha and subsequently notified on 15th of July 2019. And the two key features of this amendment was that it is undoubtedly one of the most important amendments ever made, because it brought about the introduction of Arbitration Council of India, and the objective and the aim was to encourage arbitration, conciliation, mediation, and other forms of alternative dispute resolution mechanisms, and which was obviously be elaborated by our amicus for today's session, Mr. Prakhar Agarwal. Another key amendment that took place was amendment to Section 11 of the Arbitration Act, which inter alia provides for the appointment of arbitral institutions by the courts. That's right, not ad hoc, wherein we have a retired judge or a senior advocate being appointed, but arbitral institutions by the courts under Section 11 when parties disagree upon the appointment of arbitrators. So this would obviously not help in decreasing the backlog of cases which are already there before the courts, because the courts are already overburdened, and will also reduce the burden to a certain extent. So, Mr. Agarwal, the stage is all set. The first segment, over to you.
So before we begin about the topic, I would just like to start that the arbitration law in India was primarily first governed by the Arbitration Act 1940. And then in 1996, with the promotion of the Untitled model law, the government brought in key changes and introduced the Arbitration Conciliation Act 1996 to bring India at par with the Untitled model law. However, the 1996 Act 2 has been considered as arbitration agnostic, as there are no provisions specifically towards institutional arbitration, which is in deep contrast with the practice of arbitration in Singapore and Hong Kong, as both the Singapore arbitration law and the Hong Kong arbitration law mandate a single arbitral institute to handle all the arbitrations in the country. Singapore has the SIAC, which is called the Singapore International Arbitration Center, and the Hong Kong has the HKIAC, the Hong Kong International Arbitration Center, to deal with all the matters pertaining to arbitration. And it is by far the default appointing arbitral authority, where parties are unable to come to an agreement on the appointment of arbitrators. However, the Indian Arbitration Act was completely silent on this aspect. Now, the government, with the current scene of globalization in the world, wanted to bring India at par with best arbitration practices. And therefore, the government constituted a high level committee under the chairmanship of Justice retired B.N. Sri Krishna, who is one of the leading arbitrators in the country, to undertake and identify the concerns in the development of institutional arbitration and prepare a roadmap for the country uh, to bring a robust center for international and domestic arbitration. And therefore, when this 2019 amendment was passed, it brought in key changes from the high level committee report under the chairmanship of Justice Sri Krishna. However, even though this amendment has passed and this has introduced Part 1A to the 2019 Amendment Act, which brings upon the Arbitration Council of India, whereby key amendments have been made, as you have said, to Section 11, whereby first, what the High Court used to appoint an arbitrator. Now the scene is that the High Court would appoint an arbitral institute which shall overlook all the arbitration process. And therefore, Part 1A, which is the Arbitration Council of India, has been made a body corporate under with a definite council to look after all these arbitration councils. And out of these arbitration councils, the High Court or the Supreme Court can choose one to continue the arbitration process. Now, however, we understand that the law made by the government has fixed upon the composition of that arbitration council to be one which has a chairman who is the judge of a Supreme Court or the retired Chief Justice of a High Court or a retired judge of a High Court or a person who is an eminent arbitration practitioner, But when we see the Justice B.N. Sri Krishna report, the composition specified there and what has come up in the law are totally different. Now, I'll first deal with what the recommendations of Justice Sri Krishna's report were. The Justice Sri Krishna recommended that the Arbitration Council of India should have a governing board which shall comprise of first a retired judge of a Supreme Court of India or a High Court who has substantial knowledge in arbitration, who should be nominated by the Chief Justice of India. Second, an arbitration eminent counsel who has knowledge in both international and domestic arbitration, which should be nominated by the central government. And third, an overseas arbitration practitioner having substantial knowledge of international arbitration so that one can also understand the international dynamics to arbitration and bring that to India. And he should be nominated by the Attorney General of India. And one nominee from the Ministry of Law and Justice, and one representative of commerce and industry bodies such as FICCI and other organizations, which should be chosen on a rotation basis by the Ministry of Commerce and Industry. So the governing board, as mandated by the Justice Sri Krishna report, were 5 people. And out of these 5 people, they'll sit together and choose their chairman. So by default, the retired Supreme Court Justice would not become the chairman. However, in Part 1A, Section 43C, which enshrines about the composition of the council, it is stated that the arbitral council will be a body comprising of the chairman, who shall be a retired judge of the Supreme Court or a retired judge of the High Court or the Chief Justice of the High Court, or an eminent person having special knowledge about arbitration, as nominated by the central government in consultation with the Chief Justice of India. Second, an eminent arbitration practitioner who will be a member, again, appointed by the central government. Third, an eminent academician having substantial knowledge of alternative dispute resolution processes, chosen by the central government. And there'll be 2 members, ex officio members, who will be Secretary of Department of Legal Affairs, Law and Justice, and Secretary of Department of Expenditure, Ministry of Finance, who will be ex officio members of this council, chosen by the central government, and one representative of this recognized body of commerce and industry, chosen by the central government again, which shall be on a rotational basis. Now, this entire council, the composition is pro-government. Government has every influence in this, and therefore the independence somewhere or the other goes for a toss. With and again, the other moot question is that the high courts are not empowered, the high courts or the Supreme Court, as the case may be, are not empowered to select a particular arbitral institute for arbitration. No, they have to only select any of the arbitral institutes which are graded by the Arbitral Council of India. Because Part 1A mandates that all the institutions in the country shall be designated and graded by the Arbitral Council of India. And once they have been graded and approved, such list shall be forwarded to the Supreme Court and the High Courts, who shall then select one and nominate them to do the arbitration processes for the matters before them. Therefore, this is the biggest irony. Arbitration centers such as SIAC, HKIC, or ICC, which are one of the leading arbitration centers in the world, will now have to go through this cumbersome process of getting graded by the Arbitral Council of India before they can actually begin conducting any arbitration in India. So this is one of the biggest setback for India to coming for Indian arbitration to accept the globally accepted international practices. Therefore, we since this is not notified yet, this particular section, therefore we cannot speak much about it. But such steps again bring about the pro-governmental approach towards arbitration and reduces the impartiality which can be uh, seen in the other countries' jurisdictions regarding arbitration. The other thing is, India is a host to a number of arbitration centers. When we see Indian arbitration centers, we have Nani Palkiwala Arbitration Center, Mumbai Center for International Arbitration. Recently, the New Delhi International Arbitration Center has come up with the 2019 Act. We also have the Delhi International Arbitration Center. So there are varied Indian arbitration centers specifically to deal with the arbitration, to deal with the conduction of arbitration proceedings. So the other issue that arises would be that, let's say, if Delhi starts doing all the arbitrations through Delhi International Arbitration Center and Rajasthan opens up another arbitration center, there are chances that the uniform arbitration process shall be just a myth, because every arbitration center will have its own panel of arbitrators, will have its own set of rules. So to bring this will also hamper the uniformity in the arbitration practices. The other point is that, let's say there are certain provisions which the Arbitration Council of India has approved. When we talk about emergency arbitration, which has been doing decent rounds, so ICC, SIAC, all of these arbitral institutions have a procedure for emergency arbitration. But as far as we are concerned, the Indian jurisdiction is concerned, we do not particularly accept or clearly demarcate the emergency arbitration in India. So there will be a conflicting approach if a particular institute has the procedure to adopt emergency arbitration and the Indian centers such as MCIA or DIAC do not accept those. So again, the uniformity will go for a toss. The other part is that the Arbitration Council of India, which is, we shouldn't say this, but yeah, it has a lot of governmental influence, will be grading the arbitrators per se, the particular arbitration institute which has come up before it for consideration. So there is a high chance that these arbitral institutes will favor those arbitration practitioners who have given an award in favor of the government. This is simply what the jurists are contending. But yes, when we say about independence and impartiality, this creates a lot of doubts again in the minds of arbitration approaches. The other part of the arbitration council is that uh, to have a uniform approach and to properly see institutional arbitration in the country, we first need to regularize and make a uniform procedure for all the arbitration centers in the country. And it is not that we should simply follow what the procedure of Singapore or Hong Kong is to just have one particular arbitration center, but with the non-acceptance of any foreign arbitrators in the country, this also creates a big barrier for India to come up on any pedestal on the international arbitration standards, as the government has clearly declined to accept the recommendation of Justice B.N. Sri Krishna for having an overseas arbitration practitioner on the body of the Arbitration Council of India. Therefore, again, if when we say about multi-million arbitrators, why would two MNCs try to would arbitrate in India when they know that only Indian arbitrators are allowed? So again, that will be a big roadblock to forming the institutional arbitration in the country. The other issue that comes up with the part 1A is that when we recently, I was hearing Justice Chelameshwar speak about a cooling off period for Supreme Court judges. Now, this particular fact goes again when we say that the government shall appoint them for 3 years, because the tenure of the governing body is 3 years. For the chairman, it is when he attains the age of 70 years, or for the members, it is 67 years. So again, we are moving and again going by the fallacy that arbitration should be conducted by retired Supreme Court or High Court judges and not by members of the bar. Now, this is a difference in jurisdiction, what I felt from Bombay, and you can always attest to this fact that I being I was interning at different places in Bombay, and I've seen the judges of Bombay High Court simply appoint young members of the bar just by looking at them, that what is your name, because they used to appear regularly before them, and simply appoint them in arbitrations. When we see about Rajasthan, or let's say the tier 2 cities in the country, the process is very rigid. If there is an arbitration, that arbitration shall solely be conducted by either, if it is a high value arbitration, by a retired High Court judge, or if it's a lower value arbitration, by a retired district judge or a retired judicial officer. Still, members of the bar are not promoted enough to conduct these arbitrations. That is per se ad hoc. So again, with coming of these institutional arbitrations, once you apply for getting aggregated as an arbitrator, there are uh, serious doubts whether young members or whether advocates would be appointed as an arbitrator even through these institutional arbitrations. So these are the basic issues concerning the Arbitration Council of India, because it has opened floodgates to red tapeism and government interference in the entire arbitral process. And in this current form, the arbitration goes one step ahead. The arbitration in the country goes one step ahead, but it obviously goes two steps backwards in concerning with the international best arbitration practices, what the term they use. So we would have to see about how the Supreme Court goes through the entire 2019 Amendment Act, and how when this uh, arbitration council comes up for notification before for is notified, then what is the stage for it? Because it is just a headquartered, it is, instead of being a promoter, it is simply a regulator in the arbitration process.
Yes, thank you so much there, Mr. Agrawal, for your valuable insights. Certain really very valid, logical, plausible points that you made with respect to the independence of this institution and how and what it has to undertake to match the standards set by Hong Kong or Singapore institutional arbitrations. I guess, it'll be interesting to see what happens and what is there, what will unfold in the later years, because it is too early to say. But most certainly, I think it is very important, even in Section 11 applications that are preferred before Honorable High Courts, to appoint younger members of the bar, specialists, rather than our obsession with constitutional office holders and bearers, to appoint them. It will not only encourage and motivate them, but also the research that they will probably carry out will definitely help and go a long way in deciding a dispute within the time frame that is framed as per the provisions of the Act. So it is very important even for the state of Rajasthan, for that matter, to absorb and imbibe what other states are practicing by appointing younger members of the bar and even domain experts for that matter. You know, for example, if there's an engineering matter, then why not appoint an engineer who's a specialist or superintendent engineer? Electricity matter, why not appoint someone who's heading the department? So it's always better to that a dispute is resolved by or settled by someone who is an expert.
Exactly. And when we say about international arbitration processes, we have clauses that one member shall be appointed by each party, and the third member shall be a specialist of that particular field which shall be chosen. So that helps. Let's say if we two people are a part of an arbitral tribunal, wherein we are dealt with maritime arbitration or maritime engineering processes, there are high chances that we are not able to understand what the particular technology is surrounding that, and we need an expert. So that ways it's always useful to diversify the arbitral tribunal per se, and have at least one member who is an independent member, but he understands the basic complexities. The other part that I would also like to mention that recently there was an uproar regarding appointing arbitrators as judges of the High Court. Now, that before doing that, we first need a strong arbitration bar when we have these high court associations. Or recently, the entire issue that the Supreme Court Bar Association should have a search committee for appointing judges, lawyers of Supreme Court to the high courts.
Yes.
For appointing judges, the arbitrators or arbitration practitioners as judges, we first need a strong arbitration bar who is basically given an opportunity given an opportunity to have a dialogue with the concerned officials regarding arbitration processes in the country. Otherwise, there is no particular arbitration bar dealing with specific matters. It is all the practitioners who do both things.
And I think to add to that, Mr. Agrawal, even lawyers and younger members of the bar, for that matter, who have specialized in arbitration matters by doing their master's program or pursued masters in arbitration, or who have done a comparative analysis between the Indian arbitration and other arbitration statutes, who have specialized, taught, even professors for that matter. Why not?
Exactly.
Someone whose concepts are razor sharp and who has the adequate experience. Why not appoint that person? Because arbitration is not restricting any appointment of arbitrator to a particular category. Let's say a judge or, why not? I mean, it's always better to explore and get the best of it.
And it is basically that we need to come out of this fallacy that arbitration can only be conducted by judicial members.
Exactly.
Even experts can do that.
And I think there could be probably two people doing it. One could be a judge and the other could be, but in consultation with a judge, because obviously a judge would know how to write a judgment, how to make sure that everything is carried out legally and earliest possible way. But also, I think expertise of that domain expert would also be required.
Exactly. And to add to that, instead of as I am sorry, I would have to take a name, but as a young boy, I was always in awe of Justice Sriram of the Bombay High Court. And I had seen this myself, that there was a young lawyer arguing before him, and he argued very well. And he simply, after the matter, there was the next matter, he just asked his name and he appointed him as an arbitrator. So we need to have this practice in almost all the high courts, rather than these commercial, rather than these Bombay High Court or Delhi High Court, and appoint young members. So this is one thing that I believe Rajasthan or high courts such as Madhya Pradesh or these high courts who do not have that much of commercial arbitration work should accept, because that is the growth of their young practitioners also.
I think with lawyers like you, Mr. Agrawal, tides will turn and there will always be light and things will change, equations would happen, and I'm sure we'll have younger members of the bar heading and leading arbitration from the front. So thank you so much there for your valuable insights. Now moving forward and to our next topic, which is undoubtedly one of the most important topics. That it could be a topic, it could be an issue, it could be a question mark that every law student goes through, Unfortunately, this is something that is not catered to at the first instance. People ignore it, and then the obsession of a law student with the quantity and not the quality of internships.
Exactly.
I would do 10 if my friend has done 5. I would do 15 if my friend has done 12. It's not about those number of internships that you show on your CV. It's about the quality of internships, the length, the duration, and how long have you been in that chamber, in that office, in that law firm. What all you have learned, what all skill sets you've inherited, what you've seen, have you been able to imbibe it? So that is so very important. So Mr. Agarwal, please go ahead. Over to you on
I
strategizing
I would
internships.
I would simply say that recently, because I was recently a 2020 graduate, I can say I can share a handful of my insights regarding this particular thing. That we as law students, specifically a government law college, we are not introduced towards how to go about it. And everything that we learn about how to start our internship process is through our seniors. Now, there are varied approaches to it. One, this is my personal opinion. I don't know if you would agree to this or not, but I would simply say that we should not rush for commencing any internship at any place for taking a certificate that okay, first semester this, second semester this. I believe in your first semester or in a second semester, you have zero knowledge about what the law is or how the law actually works. So if you work in a law firm, be it in Jaipur, Delhi, Bombay, any place, everything will go over your head, and somewhere or the other you will have this feeling that you have taken a wrong profession. Luckily, if you have someone in the legal fraternity, he'll be able to guide you and tell you things will come up with time. But for a first generation lawyer or a first generation law student, it will be tough for him to survive that particular 4 weeks of internship, because he'll be thrown with so many legal jargons that he might end up uh, just completing the law degree and choosing some other profession. So I would recommend that first year law students, instead of working at law firms or with lawyers, senior counsels, they should start working with uh, quasi judicial commissions under some judge and read under some members or judges. For example, one can easily intern with the state consumer commission or the lokayukts, RTI commissions, even the Vidhan Sabha, for the matter of fact, human rights commission, and understand legal service authority and understand the easier processes, or no, I should not say easier processes is the wrong word, but understand the processes of law uh, which are not directly controlled by the courts, or which are basically a pro legal or a pro bono services, in which there is not much of a rigidity, so that you have one avenue which you have worked, which you've understood, and which you can understand even without reading the entire CPC CRPC. So that will help you. And it is not just that you need to do an internship for for your CV, or just for the sake of getting a certificate to write it in your CV. One should do an internship in a particular area of law that he wishes to understand, and instead of applying to 10 different places at one time and getting one internship, you should apply to 5 places where you really want to work, who does a particular who does or practices a particular area of law that you are inclined to practice in your future, or you want to learn it. And then you go for a 4 week internship with that place, understand it, and do not go behind the numbers. It is about uh, the matter that you learn. Let's say if you work at one place for 6 months, and you say, "Arey, I just have got one CV where my contemporaries have worked with 6 different law firms and have 6 certificates." That is not a point. If you have worked there for 6 months, uh, if you're working there for 6 months, definitely you are liking the work environment and you're learning something. So your intellect ability has obviously increased. B, if you work there for 6 months, you are very well versed with the entire process of that particular office, and you have built up a certain relationship with your partners or the associates. which you enjoy. Therefore, the chances of you converting from an internship to a job highly increase. And I've seen this from my personal experience, from my contemporaries' personal experience, that if you enjoy at a place for 6 months, continue working there, there are, if the firm is not taking a, if the firm is not hiring for that particular year, that is different. Otherwise, you are a short candidate for their associateship. So that is not a concern for any law student. The other thing is, you must choose what area of law you want to go, and do not just hang around that you do one internship in a corporate area, the other in an IP sector, the third in litigation area. Till your third year, you should have a fair bit of idea about what things you need to do, or what you incline to do so, and then you streamline your internships towards that particular facet of law. Otherwise, that looks in my opinion, that looks a very haywired in your CV. That okay, first you did a corporate internship at a law firm, then you went to a district court lawyer, worked there for a month, then you came, then you had a judicial internship. That looks a diversified CV, but at the end of the day, when you say that okay, let's say even if you are applying for your LLM master's application in human rights law, you cannot particularly uh, enshrine that okay, you have a deep interest in human rights law, because all in your 5 years of law, in your 3 years of law, you were doing totally different things. So that is why it is important to understand what area of law you want to pursue, and do it after, and continue doing internships in that particular field from your third year, or from your second year for the 3 years law school, the law candidates. The other aspect of this particular issue is that uh, we need to come up, and I'm sorry if I'm coming up as criticizing everything, but there is a high need to change the internship system, that students are just simply doing internships in in this issue, or in this doomsday mechanism, that they would not land up anywhere if they do not intern. That is not the point. If you intern at a place which does not really require an intern, you would not learn a lot of things. And we should stop this mechanism that students are interning at almost every other place. You need to understand that your mentor is uh, is the one who basically helps you out in everything. And if he does not teaches you much, law is such a vast field that sitting in an office, you will not be able to learn a lot of things if there is not some if you do not have someone in the office to help you out with stuff. Therefore, we should regularize internships, and if we then we can say it is a very far-fetched thing, but I think in the coming years, with the radical changes in the education system, even the bar council will come up with for practical training aspects for 6 months or 3 months, compulsory practical training, whereby students will be pushed to intern at places and learn the practical nuances. Otherwise, when we say if we even if we attend lectures every day and understand all the concepts of law, for litigation per se, it is very important for you to know how to apply these legal principles in its practical sense. And which I can vouch for this, that had I not done my internships, I would not have understood that your particular arguments that you need to make during your stay application, or what is this process called notice served categories for admission stage, reply awaited. So these are very practical processes that one should understand, but they are thrown to it once they finish law school and enter their litigation. So it's better you understand these processes before you complete your law school. The next aspect of this is that instead of we should understand that stipend is not one thing that you should be focused upon, and stipend is not the uh, sole reason for doing or not doing an internship. Yes, of course, I can say this, that if you are working 12 hours a day, you should be getting a worthy monetary compensation, because you're traveling. Let's say if you are from Bombay, you're traveling to Delhi for an internship. that will take a toll on your finances. And if any monetary compensation is given, you can manage your expenses, daily expenses. But I personally don't think uh, if you are getting a 10,000 monthly internship at a place and there is one place that is not paying you, you should opt for the 10,000 a month internship, because there are high chances that that lawyer or that law firm who is not paying you a stipend may give you a very flexible approach and may give you matters to read, or may give you a very easy access to matters, do not include you in client conferences, and teaches you right from the basics. So I don't think stipend should be the only concern for any law student at such an early age, let's say till your third year or fourth year. So yeah, the major thing is that do not rush about stipends, and think about how you want to progress your career path.
All right. Thank you so much there, Mr. Agarwal. To sum it up, I think it is important for every law student to understand that the focus should be on learning than to earn. And number two, academics should always be the first priority. Internships should follow academics rather than academics following internships. And it is very important for law students to understand that only when you read, you should proceed. So, for example, if I am studying Indian Penal Code or Evidence Act in my second year, I should intern in a chamber that specializes in criminal law only once I've studied it by virtue of a classroom mode through a professor who is a specialist. So only when your academic fundamentals are strong, then you will be able to understand the practical processes better, as you rightly mentioned, which are so important for any litigating lawyer or counsel. And strategizing them, and the quality is more obviously important than quantity. So doing a 3-4 quality internships will always stand out than doing a 10 internships that are lasting only for a month. So I am sure that these valuable insights will definitely help all our viewers who are watching this. So thank you so much, Mr. Agarwal, once again.
Thank you so much, Bhaiya, for having me on this platform and for giving me an opportunity to say on these particular topics.
The pleasure is mine, and hope to see you soon. Hope to see you again on another segment. Stay tuned, everybody. The next episode is on its way. And stay home, stay indoors. COVID is still around. It's goodbye for now. Thank you.